And I will turn the microphone over to Professor Irma Russell, who will introduce our first speaker.
Thank you, Sam, and thank you for all of your hard work on this issue, and all the issues of the journal. Well, I have to apologize for my voice, but I will be brief. It's doesn't feel quite as bad as it sounds anyway. It's my pleasure to introduce Professor Katherine Sharkey. She is a faculty member at NYU. Her areas of teaching and research are torts, punitive damages, class actions, remedies, products liability, and empirical legal studies. She served as law clerk to Judge Guido Calabresi and as clerk to Justice David Souter on the U.S. Supreme Court. Her degrees are BA in economics from Yale and a JD from Yale. She will discuss her writing today on the very provocative topic of eschewing the Aristotelian golden mean. Professor Sharkey.
Thank you. So I'm told I have 45 minutes, and I will try to keep myself to only 30, but also if people have questions as I go, I should maybe say with a caveat, perhaps Professor Epstein should wait until I'm finished, but anyone else should feel free to interrupt as we go. All right. I'm delighted to be here, and I want to thank all the editors of the Tulsa Law Review thus far, and I know we're only at the very beginning. The hospitality and organization has been phenomenal, and it's very much appreciated. I am going to talk about eschewing the Aristotelian golden mean, and before we get to the title, I thought I'd give a little bit by way of background, the kind of circle of my professional life that comes back to Richard Epstein. So 15 years ago, I was transferring from economics. Actually, after I got my first degree in economics, I went to economics graduate school and then got lured into the law. And so I was that unique law student who arrived as a first year and was particularly interested in torts. Right? All of my first year classmates at that time, they cared about constitutional law or other things. And in particular, I was drawn to Yale because of Guido Calabresi and because I thought I wanted to study torts with the person who I thought was the master. So the cosmic, so to speak, at that time, and I was in my 20s, so the cosmic injustice I felt that was bestowed upon me was when we got assigned our professors, as is the wont of law schools, had Jack Balkin teaching me torts. Now, Jack Balkin, who I might add is a phenomenal teacher and scholar of First Amendment law and constitutional law, had what I'll call a kind of disdain for torts. In fact, he taught the entire course as a course in rhetoric, just the ability to make competing arguments on different sides of issues. So I was deeply disappointed, but the silver lining in all of it is he had the wherewithal to have adopted Richard Epstein's casebook. And this was a casebook that I found intellectually very, very rich, and it actually sustained me for my entire first semester, at least, of law school when I thought this otherwise cosmic injustice had been perpetrated upon me. 9 years after that, when I entered the academy myself, therefore, it was sort of a natural choice that I went back to the casebook that I had a certain fondness for and adopted it in my first torts classes. It was a couple editions later, but I still found it very much rewarding. And it was actually at that time, about 6 years ago, that Richard and I had our very first phone conversation, because I guess I had the hubris, having studied as a law student with this casebook, of feeling a certain fondness towards it and then adopting it myself in my own classes. I didn't have colleagues who were particularly engaged in torts, so I thought I'd reach out to Richard Epstein, who by now I thought was the real guru or master in the law of torts. So I sent him my first law review article, a draft of an article I was writing called Punitive Damages as Societal Damages. We didn't otherwise have any kind of contact up until that point. And I was sitting in my office one day. I was a fellow at the time at Columbia Law School, and I got a phone call. And I picked it up, and we then proceeded. I would call it a conversation, except I was silent. We then proceeded for the next hour to, I'll call it at least engage in the substance of my article. It was at the time, and I didn't know Richard apart from his casebook and the sort of intellectual side that seemed to exhibit. At the time, I experienced it more as a tirade of about 100 things wrong with my article. I was furiously taking notes. There were a few things. He said, well, maybe you have one idea, but it's in footnote 133. And I realized he wasn't being literal. I'm looking for footnote 133, trying to figure out where my one good idea that might sustain an academic career was. But the other thing that Richard said towards the end of the conversation was he said, you realize you're taking us to hell and you don't even have a handbasket. So I thought to myself after I ended that call, it took me a while to see that phone call as high praise. It took me a long while, but once I got kind of over the shock of it, what really has stayed with me was the kind of generosity of spirit and the intellectual passion, the two combined, that I think are really what Richard Epstein is all about. The fact that he had reached out to a not even junior professor, a fellow at a law school, and engaged that vociferously with the ideas. So since then, though, in each of my academic pursuits, as I was reflecting on the substance for my contribution to this symposium, and it started actually with that article on punitive damages, I've had this kind of inner voice that's Richard Epstein saying, beware of the pursuit of the Aristotelian golden mean. So therein comes my title, Eschewing the Aristotelian golden mean. The idea being, Richard has always impressed upon me that you need to worry when you find yourself intellectually coming to positions that are basically compromise, middle of the road, finding the Aristotelian golden mean between these two opposing poles. Because what he cautioned me is that this either could mean that you somehow have come upon, right, the intellectual illumination that leads you to this golden mean ideal, or, on the other side, you might just be in a kind of intellectual, muddled, messy middle ground from which you need to emerge and adopt a position at one of the two poles. So it seems clear to me, looking back, and I've read a lot of Professor Epstein's scholarship. This symposium encouraged me to seek out yet some more, which I could read on the long plane ride here. Richard Epstein certainly practices what he preaches, namely, in almost all of his writing, there's a subtext of railing against the kind of Aristotelian golden mean position. It's sort of at the core, I think, of his debate, for example, with Judge and then Professor Richard Posner, who wants to adopt a standard of reasonableness for upholding negligence as the core standard in all of tort law, as opposed to the strict liability position that Richard would prefer. And I take Professor Epstein's foreboding here very, very seriously. So what I wanted to do in my paper and here is take up two issues that you can only pick two. I mean, Richard, of course, has tackled a million issues, so I'm going to take two issues that I've thought a little bit about. One's going to be trespass to chattels, and particularly trespass to chattels in the Internet, and the second is going to be failure to warn claims and products liability, in particular federal preemption of failure to warn claims. And I'm going to do these. I think there are a couple of things that make these two case examples interesting. They're emblematic of a couple of core principles that repeat in Professor Epstein's work, namely, and I think throughout this symposium, several different participants are going to be hitting on some of these. Namely, you want simple rules for a complex world. You want simple dichotomies. You want to think about stranger cases, like the trespass to chattel, which we're going to talk about, where one party deliberately invades either the land or the personal property of another, versus the non-stranger, or more quasi-consensual or contractual, like the products liability example. Richard, if he had his druthers, right, would probably remove the entirety or most of. He would leave manufacturing defects, et cetera, but would remove a lot of products liability and put it into contract law. So that's going to be an interesting theme that we'll come back to there. What I want to do, though, is use these two examples to, one, demonstrate Professor Epstein's consistent approach, and you'll find it in these two areas, of eschewing the Aristotelian golden mean, of being emphatic that a kind of absolutist position that he wants to take is the right one to take in those areas. And then number two, I want to try to mount a challenge. This is the harder part, of course. Finding that Professor Epstein's been consistent in his views here is going to be the easier part. Mount a challenge to his rejection of what seems to me normatively desirable middle ground positions in some of these areas. Now, of course, I take the luxury, particularly because I only have a total of 45 minutes, and as I said, I only want to use half an hour of it, that my goal here in the talk is going to be slightly less ambitious. Namely, I don't even want to have to convince Professor Epstein, I'll never convince, but the rest of you, that the normative ideal position in these two areas is a kind of Aristotelian golden mean. But I do want to show you that the following. Richard is, in one of his articles, said, quote, in practice, sound legal systems cluster close to hard and fast rules, closer to hard and fast rules than to the mushy middle gray area. The less ambitious goal of mine is to suggest that that may be so, but what happens is that Professor Epstein will articulate a polar position at this pole, and courts will adopt the position at the polar opposite pole. So what I want to convince you of is that possibly the pursuit of this Aristotelian golden mean would even get Professor Epstein to a position that would be closer to his normative ideal. Okay, so let me very quickly lay the groundwork for the two areas. First one's going to be trespass to chattel. So trespass to chattel, depending on how long your torts professor has, you may never even have encountered the issue. It comes up in intentional torts. It's when somebody intentionally takes or intermeddles with chattel, which is personal property, right? So anything that you own that's in the possession of another. The interesting application I want to talk to is this sort of old tort that gets resurrected, kind of phoenix-like, right? It's kind of died out. You have these old English and some old American common law cases dealing mostly with cows that people have intermeddled with and the like, not sort of high-stakes type issues. And then this tort comes back when people start using it in the Internet context. So basically it starts being used to police or to control things that start looking like spam, like hacking, like electronic intrusions that people want to stave off. So in this area, doctrinally, what's quite interesting is that if you look at what's required for a plaintiff to establish trespass to chattel, personal property, as opposed to trespass to real property, doctrinally, and the second restatement has pushed this view, that to have an actionable trespass to chattel, you have to show some kind of damage to the property, right? You have to show actual damage, whereas we all know with trespass to land, you don't. It's a fiction, right? If you go over the boundary of someone else's land, we sort of have this fiction that even the treading on the grass is enough to constitute the damage. So in other words, we're going to enforce very strong property rights protection in the land context, and the question becomes, why when it comes to personal property, does it seem like we're not enforcing such strong private rights of property? Now, the restatement has one sole example, which has to do with a child coming and jumping on the back of a dog and pulling its ears, right? So again, not sort of the kind of high-stakes kinds of questions that you think are going to be involved in tort law. And the restatement basically says that there it's done no harm or injury to the dog, and therefore it's not going to be actionable. And after all, you can remove the dog. You can take the dog out of harm's way. And so, in essence, if you piece things together, it looks like what this doctrinal requirement, and certainly the example given by the restatement, is trying to do isn't to set up a hierarchy, right, to say that land's important to protect but personal property is not, but instead has something more to do with the ability for movable personal property or chattel for you to avoid the harm, right, to just take it out of harm's way. And in fact, the restatement talks about, and I'll quote here, the fact here that there's this difference comes from the fact that there's, quote, a privilege to use reasonable force to protect his possession against even harmless interference. So the key, and Richard Epstein in several different law review articles has emphasized this point, that the key to understanding what's going on in this dichotomy between protection of land and property is the ability to exercise self-help. And he's guided scholars and courts to sort of think about what we need to do is reconceptualize what self-help might mean in the context of the Internet. And what he tried to do, I'm going to tell you about one particular case where this came into play, is what he wants to try to do is move courts, I think, off of what's become their mainstay when they look at these trespass to chattel cases, which is that they're obsessed with trying to figure out what is harm to the property. Right? They're obsessed with trying to figure out in these electronic intrusion cases whether harm means that you have to, by throwing all these emails or spam towards somebody, you slow down their server, you impair its operation, whether it can include things like you don't do any kind of physical damage, but you have a threat of potential future harm. right? So one, this has come up in auction type sites where people come in with their spiders and are trying to take various material and then use it on their own website. And the idea is maybe one invasion wouldn't cause any kind of harm, but the threat of future further invasions might lead to that. And finally, there's a question of whether you can extend this to what are sort of economic consequential damages, to things like loss of employer productivity, loss of reputation, loss of goodwill, and the like. So the doctrinal case that I want to talk about, and it's also interesting because Richard Epstein himself played a role in this case, arguing for the ultimately losing side, which is key to my to where I'll end about this maybe possibly having a strategic concession that sometimes the Aristotelian golden mean might get him closer to the end. So there's a case called Intel versus Hamidi, and very briefly, this is a really fascinating case, one that I love teaching in torts class, not only because I have this great clip from Anderson Cooper that has Professor Richard Epstein debating a young lawyer who was fresh out of law school when he decided to take Mr. Hamidi's case on. So it's the one time the students can see the real Professor Epstein kind of in action in this clip. But the case itself is actually quite interesting. Professor Epstein called it an instant legal classic. He also claimed that it was the most significant development in tort law in about a decade. So again, we're back to the idea that it's this old arcane trespass to chattel that gets resurrected and used in a very modern context. So Mr. Hamidi, in sum, is a disaffected former employee from Intel. And what he did is he set up a website called Face Intel, and on this website he has all of his rants about everything terrible that the company's been doing to him throughout a long, prolonged history. And instead of just having his website allowing people to come to it, he decides to send, he surreptitiously, we never know exactly how, he surreptitiously gets email addresses from massive numbers, hundreds, tens of thousands of current employees at Intel. So he gets this listing, and he uses it to blast, right, these massive emails, about 8 of them to 30,000 some employees that include his tirades against the company. Intel, of course, doesn't like this. So what does Intel do? One, it tells him to stop. This just seems to encourage him, right, to do it more. And two, they start expending efforts in self-help, right? They get their tech guys. It's kind of, there is a certain irony, right, that Intel, with all of its sophistication, can't keep out Mr. Hamidi acting alone. But putting that aside, they seemingly can't stop him. So Intel decides to sue Mr. Hamidi. And what's the ground of their suit? Well, there are a couple of things that they could choose, and it's actually sort of interesting strategically to think about this. They don't choose to sue him for defamation, to say that what he's saying is just untrue and actionable. And there are a couple of reasons why. One, they don't really want this to become a battle where they have to be proving the truth or falsity of what he's saying. They don't want to be repeating all these awful things that are being said about them. But also importantly, they don't want to have to establish damage, because that's going to be really difficult for them. So they sue in trespass to chattel, and they sue for injunctive relief only. Right? All they want is Mr. Hamidi to stop intruding on their private personal property, their server system, their email server system. So this case has a sort of up and down quality. The Epstein position, I should just be very clear. Epstein's position, of course, right, is that we're talking about enforcement of private property rights. In this instance, Mr. Hamidi has invaded the personal property of Intel. And in trespass to chattel, well, it may be that doctrinally courts have said you have to articulate this kind of harm to the server. Epstein made 2 moves. One, he said the real analogy is trespass to land, right, not trespass to chattel, and so therefore we shouldn't have to satisfy the damage requirement at all. This fails, and I concede the court goes on a kind of harebrained analogy of saying things like, even though we use metaphors, the architecture of the internet highway and things that seem to be placed, there's sort of metaphors for real property. They say, after all, internet, this could be like a net, it could be like a fisherman's net, and that's like personal property. So that's bizarre, and I can see that, but I can also see why a court wouldn't want to suddenly decide that in this new medium of the internet, they're going to transform trespass to chattels to trespass to land. So the second argument, and the one that I want to focus more on, is this argument that says, well, in an instance where Intel can exercise self-help, right? Because there's no claim here that Intel wouldn't be able to just get more sophisticated IT folks in and have them block Mr. Hamidi or have them reconfigure their server so that it didn't give him access. So Richard's claim is in that instance, just because you have the right to exercise self-help, that ergo you have very strong property rights that should be enforceable by a property rule or by an injunction. So you shouldn't have to show anything like damage. Now, what's interesting, the court rejects that claim, and the court, apart from rejecting the trespass to land analogy, emphatically wants to hew to the fact that doctrinally you have to show some kind of damage. And in fact, not only this court, but every court to look at this issue has basically rejected the Epsteinian strong property rights position and has instead kind of, the whole debate has been how narrowly or broadly are we going to interpret damage, right? Do you need to have actual physical damage to the server, where, as I said before, it slows it down, it keeps people from being able to use it, or could it extend outwards? Could it extend out to more consequential economic losses and the like? What I think is interesting about this example is that if you step back and you use, and yes, you will come up again, the Guido Calabresi, Douglas Melamed, property rule, liability rule type framework, and you try to ask yourself, who has the entitlement here, right? In other words, Hamidi clearly has no entitlement that he can force his messages into the server. At the same time, the court seems to be saying Intel has no absolute entitlement, right, to stop him through an injunction. So it looks like where we're left is a kind of hybrid type entitlement. So this would be a kind of Aristotelian middle mushy position. Now, what I want to argue is that possibly in this instance there are some kind of hybrids that we might want to consider. This would be the sort of anti-Epsteinian move. So Epstein says, quote, "This critical misunderstanding of the way in which a sound property system is organized will invite courts to weaken the critical exclusivity requirement in favor of complex judicial schemes that decide which cases of exclusion are allowed and which are not," right? So simplicity is good, complexity is bad, private property rights are good, and any kind of compromise on exclusivity is bad. Now, the interesting thing is that in a world, and this is where I'm going to slightly hedge, I'm not going to defend the normative ideal, although my paper will go in that direction, but in a world where courts are not going to be attracted to or embrace that absolutist polar position, the fear is, if you continue to just press or adhere to that position, that they gravitate to the opposite. So the Intel, California State Supreme Court, and numerous other courts, influenced, by the way, by other academics, including people like Larry Lessig, Mark Lemley, are so worried about the quote-unquote propertization of the Internet that I think what it does is it makes them go off the rails, right, instead of trying to figure out whether there are certain instances where they actually should give a kind of enforcement right to protect a kind of hybrid entitlement. So what would this hybrid entitlement look like? I think that we should at least consider the following. Consider whether courts should instead think about the invocation of self-help measures as a kind of threshold requirement to be able to invoke the legal process. In other words, Intel has to do more than just come into court and say, we have this right to exercise self-help, ergo, we can get an injunction to stop someone. What they would have to do is to demonstrate to the court the reasonable, here comes that awful word again, but the reasonable practices whereby they tried to exercise this kind of self-help. And maybe if they can show that they entertained those and then they failed, that they could invoke legal process. This, by the way, would be similar to things like posting laws, fencing out laws, other types of these kind of hybrid solutions in property law. It also might behoove us to think about self-help here as serving as a kind of sincerity index, right? Because if we do fear, as courts seem to fear here, that too strong enforcement of private property rights is really just a subterfuge for the critical, either free speech, First Amendment, or protection of free flow of ideas to and from sites. If they're worried about that, then maybe they would be convinced that so long as there's something that shows what I'll call the sincerity index, namely the sinking of an amount of money to exercise self-help before coming into court, that would allay some of those fears. It also might help, finally, in terms of one of the difficulties the courts seem to have is even if they're willing to entertain a broad definition of harm in trespass to chattels, they're worried about how we're going to monetize that. And so here the idea is that actual self-help measures themselves might be easier to monetize, and therefore we could get a proxy for harm or for loss. Okay. I'll take one breath. Now I'm going to go very quickly to issue 2, which is a slightly different issue, but I'm not going to go into it in as much depth because Richard and I have already debated this issue in the Northwestern Law Review, and I don't want to repeat that in this piece, but I want to give you a little flavor of it. This is the issue of failure to warn claims in product liability, and in particular the idea that federal law would preempt or oust state common law. Now again, just to set the stage, right, the Epsteinian absolutist position is going to be what's called field preemption, and in fact his contribution in the Northwest Law Review is called something like the case for field preemption in FDA drug claims. My position in the mushy middle has been one that I'll call the agency reference position, and that mushy middle says that just because the FDA approves a drug, that doesn't mean that in all instances the state common law tort claim should fail, right? That's the field position type view. What it tries to do is come up with a very complex, so we trade off simplicity here for complexity, a very complex sort of way in which it's actually not that complex, but as compared to the absolutist position, it's more complex. So the idea here is that you want to have courts look, and in instances, for example, where the FDA has weighed in on the particular risk that came to light, that's the basis of the state tort claim, you would preempt those claims. You wouldn't allow for juries to redo the very same cost-benefit or risk-risk analysis that the FDA had done. But in an instance where, for example, there's initial approval of a drug and then nothing further, and a new risk comes to life after the fact, and then the FDA and the drug manufacturer run in and try to say preemption on the basis of prior approval, you wouldn't preempt in those instances. So the reason it's complex, or here's the shorthand version of Epstein's critique of my position, would be one, it consciously incorporates administrative law principles, right, into this area, and that's the last thing you want to do, right? The whole world went off the rails with the New Deal and administrative law standards and the like, and in terms of trying to ask courts to import some of those principles and trying to do judicial review of what agencies are doing, you're going to go further off the rails. The one I want to emphasize or end with, really, is he then says the flexibility of Sharkey's agency model aims at the flexibility of Sharkey's agency model comes at too high a price. Now, I find this deliciously ironic, right? Because here, now I come to my final point, which is that even if we're not going to believe normatively that the Aristotelian golden mean positions are correct, I want to argue that Epstein's more absolute positions here come at an even higher price. Namely, what does it do? Courts, as I said, are gravitating not towards the messy middle, but towards the opposite pole. So I told you in Intel, courts fearing the quote-unquote propertization of the Internet go to this bizarre alternative scheme. The same thing happens in federal preemption. How does this happen? Courts who fear this kind of field preemption where inept, unfunded agencies, just because they're in the game at all, are going to preempt entirely state tort law, they invoke the presumption against preemption. Right? So this is the statutory canon, which is devoid of a lot of what I think intellectual content, but nonetheless, they invoke it, and they invoke it to withstand the fear that otherwise we would gravitate towards the opposite pole. So the very final point that I'll make is on the way here, as I said, I always try to expand my horizons, and I thought I'd read most of what Professor Epstein has written, but I came across this curious article that I'd missed called "What Not to Do About Obesity, a Moderate Aristotelian Answer." And I have to say, I was so intrigued, I almost fell out of the seat in the airplane, published in the Georgetown Law Journal in 1995. And in it, here's a quote, but I'm selectively taking it out of context. I'll concede that at the outset. He says, "Ideally, we should all be willing to follow a simplified version of Aristotelian ethical theory, which holds that moderation in all things probably works for the good." Here. Now, here's where I was being a little bit covert here, because of course what Richard's talking about here is the fact that Aristotelian moderation, right, in other words, each of us taking personal responsibility for not drinking too much, smoking too much, eating too much, right, will lead to this Aristotelian position where we have no regulation, right? We have no need for the government to intervene, to start imposing regulation and costs on fast food companies, no lawsuits are necessary, etc. And I realized at the end that, alas, poor Aristotle is really just a stand-in. He's just a stand-in for government intervention and regulation. And now I understand, I think, why it is that Richard has eschewed the Aristotelian golden mean. But I would implore him to take another, quip that he might take up, that the perfect should never become the enemy of the good. And so maybe we shouldn't be so forceful in our rejection of poor Aristotle. Thank you. No one interrupted me, but I'm happy to take questions. Yes. I know you have. Oi, Stan, what a nuisance. Hmm?
So rest following, so maybe because that doctrine by reason. But even though it's because that doctrine always has its advantage environment, with the stats very often the act of taking someone's saddle or
Right. There's a divide, at least. I remember I went back and looked at some of the earlier cases, and some are emphatic there needs to be some kind of damage to the good, and some are more emphatic that it's the violation of the right, which gets back to, Professor Epstein's point that there are trespasses in both instances, just one is actionable in the real world versus the other. But yes. Yes. Right.
Talk about after the court you expect he's an interference.
Mm-hmm.
Right? I mean, the property law already provides the opportunity
right.
without having raising long-standing concepts of that pre-existing without having to violate.
Yeah, no, it's a good point. So here's the cagey answer, right, is that I'm more willing that doctrinally out in the world, the way courts are employing the nuisance doctrine, that we really have the mushy, messy, reasonableness, what the heck does that really mean type analysis. And of course, Professor Epstein's written very forcefully of a different kind of clear-cut interpretation, leaving minimal intrusions to the live and let live, and then having strict enforcement. So so my normative embrace of the kind of standard that I was talking about here, which would engage a kind of balancing type test, you're absolutely right that a response to that would be, we'll just go ahead and adopt nuisance doctrine. In this piece, because I'm taking on, Professor Epstein's particular approach in this doctrine, I have a different aim in mind. And the only thing I will say is that I do think that they're sort of the more abstract point that I would want to make is that when you're taking kind of an old tort and applying it in a new area, and we see this throughout in a lot of different areas, right? You see conversion claims being applied to biotechnology and the like. I actually think it's important for courts to not just hew, particularly in instances where doctrinally you can trace a split, and that's why at the time when I was thinking about this, I went back and looked not just at Prosser and which splinter he wanted to adopt, but the split in authority there, that you kind of take a functional approach and ask, why is there this requirement? And that's what I embrace or like in Professor Epstein's approach, is he says, listen, so we said you had actual damage, but given that you could remove the personal property and exercise self-help, why don't we think about how we should conceptualize self-help in the internet versus the real world? And that leads to an interesting inquiry where you say, well, in the real world, you worry sometimes that self-help will lead to actual physical violence. So you want the law to intervene and stop it. You don't have that concern, in the internet. And then you ask yourself, well, what is the concern if you allow for parties to just come and say, we have this blanket right to exercise self-help, we want to get injunctions. The court's overbreadth problem there, I think, might be solved by requiring something like having committed resources to the self-help, et cetera. I haven't worked it out entirely because I can see there's some problems with that. Namely, you could worry about abusive self-help measures and the like, but it's still better than as a sort of sincerity signal than what Professor Epstein offers. Because Professor Epstein offers just the following. Well, Intel sued after all, and big sophisticated companies wouldn't take the effort to sue if they weren't damaged. I don't think that's going to be as persuasive to courts as something like what I'm talking about. Yes.
That's the kind of oddity you have. When I wrote this thing about this, I said, look, if you're dealing on an issue, where you have open access, speak songs, everybody can enter. Oh, why is it happening?
Right. Yeah. I can see. Yeah. Right.
Nobody is interested ever claimed that they thought of the internet and so forth. So the issue is
Right.
and they can't even tell me that it's okay.
Right.
I always want to get something to these circumstances. That's why, basically, we're good cop, bad cop. I will go to you.
Right.
Apologize because pretty good in other cases. So I think I'm still an accident, but problem, I don't know.
Mm-hmm. Yeah, okay, so I'll take the easier and then get to the harder, right? On the capacity, just so that everyone understands what the claim was, and it's a very good one, is you have to worry. Let's start with how courts doctrinally are looking at harm or impairment to the server. You have to worry that this creates, just their doctrinal structure, creates this, they get it exactly backwards. Namely, if you have a very sophisticated system, it would take a huge amount to impair it physically. And if you have a really shoddy kind of system, it would be very easy to impair. So if you're worried about ex-ante incentives and where this is all going, you should be worried about that. And I can see that likewise, it's one of the problems. There's both the abusive self-help, but there is this same problem with putting the metric on the measures to exercise self-help. But maybe you could play around with that. I mean, what's interesting to me is when you read the Intel decision, which is a little bit all over the map, and adopts some crazy positions, it also rejects that Intel actually engaged in sufficient self-help. So it's a kind of interesting hook to suggest, it might be wrong factually, right, but it's again like the preemption cases, which I think they've adopted the right model to look at, did the FDA look at this issue, and then you see how wrong it can go, with the majority saying the FDA only paid scant attention, and the dissent saying they looked at it very fully. And this would be a great, counterexample to the model that I'm trying to establish here too, that it will be equally manipulable. The harder question, and that's why I said here I was, admittedly, I was doing the easier part to just sort of convince people that possibly to get to your normative ideal of protecting autonomy and libertarian ideals, you sort of shoot yourself in the foot, so to speak, by rejecting the Aristotelian golden mean position, does invite this kind of response. And I should add, just as a footnote, courts are very taken with this threat of the propertization of the internet. So one could argue either the main goal is to show them that they're wholly wrong, or to figure out how you could get the right solutions to complicated problems by sort of covering over or laying those fears. The harder question, of course, as an academic, and I aspire, I don't do these because my biggest aim is to intervene in particular cases, et cetera. It's sort of understanding why my innate attraction to the Aristotelian golden mean will be the normatively ideal position as well. And all I'm trying to do here is to show how the perfect becomes the enemy of the good in actual application. He was well lawyered. It will continue, fear not. Thank you very much.